Hello, my name is Abhishek Kumar Misra, and in this video, I'm going to discuss about the fundamental rights in the Indian Constitution. Okay, so it will be a complete video on fundamental rights, and everything will be covered from scratch. Okay, so fundamental rights. But before discussing the fundamental right, let's discuss something about the original Constitution. Okay, original Constitution. So original constitution was adopted and enacted on 26 November 1949. 26 November 1949. This is the time when original constitution is adopted and enacted. Adopted and enacted. And where this clause is mentioned on this day 26 November 1949, we do hereby adopt, enact, and give to ourselves this constitution. This phrase is mentioned in the preamble of the Indian Constitution. Is mentioned in the preamble of the Indian Constitution. Okay. And our constitution came into force, means our constitution was applied on 26th January 1950. We celebrate this day as a Republic Day. Republic Day. Original constitution had 22 parts, 8 schedules, and 395 articles. Okay, every part contains certain articles. Okay, so this is clear. So let's understand and let's find out the position of the fundamental right. Means which part of the Indian Constitution deals with the fundamental rights. Okay, and which all articles are included in that. Okay, so let's understand some more important thing, that some of the provisions of the Indian Constitution. Okay, provisions of the Indian Constitution can be categorized into two. One is the unique feature of the Indian Constitution. Some of the features are the unique feature of the Indian Constitution. Some of the provisions and some of the features of the Indian Constitution are borrowed from other constitution, borrowed from other constitution of the world, from other constitution of the world. ठीक है, मतलब हमारे संविधान में जो फीचर्स हैं उसमें कुछ तो यूनिक फीचर्स हैं जो कि हमारे कॉन्स्टिट्यूएंट असेंबली ने खुद के नॉलेज को यूज करते हुए बनाया, ड्राफ्ट किया, और कुछ ऐसे प्रोविजंस हैं जिसमें कुछ चेंजेस और या तो बिना चेंजेस के हमने क्या किया, अपने संविधान में इंट्रोड्यूस किया, और उसका इंस्पिरेशन जो आया था वो किसी और कॉन्स्टिट्यूशन से आया था। ओके, लेकिन हमें क्या बात करनी है, फंडामेंटल राइट्स की बात करनी है। ठीक है, तो फंडामेंटल राइट्स is mentioned in part 3. It is mentioned in part 3. Means the provisions included in part 3 of the Indian Constitution deals with the fundamental right. Okay. And part 3 of the Indian Constitution contains 12 to 35. The article contains articles from 12 to 35. So article 12 to 35 deals with the fundamental rights. Okay. Now, is it a borrowed provision? Is it a borrowed provision? Borrowed provision. So the concepts of the fundamental right in the Indian Constitution is modeled on the Bill of Rights of the US Constitution. It is based on the Bill of Rights of the Indian US Constitution. Bill of Rights of the US Constitution. US Constitution was the first constitution to start, first written constitution to start. It started in 1789. Okay, so it is the Bill of Rights of the US Constitution. Indian fundamental right is largely inspired from the Bill of Rights of the US Constitution. Now, let's understand some more thing. Okay, so fundamental rights are basically indispensable asset for an individual. Indispensable asset for an individual for their physical, intellectual, and spiritual growth. Intellectual and spiritual growth. Spiritual growth. Now, let's understand that if fundamental rights are not there in the Constitution of India, then the physical growth of an individual is hampered, intellectual growth will also be hampered, and the spiritual growth will also be hampered. So let's understand. Now, the physical growth of an individual. So Article 23 and Article 24. Article 23 and Article 24. It talks about right against exploitation. Right against exploitation. It prevents the trafficking in human. Trafficking in human. In human. Okay. So this article protects the people from the tyranny of the state. Tyranny of the state. So an individual is physically growing because he is protected under the fundamental law, and that fundamental law is the fundamental law is the Constitution of India, and Constitution of India confers certain rights to the individual, and that rights are mentioned in Part 3 of the Indian Constitution. Okay, how intellectual growth, how our Constitution of India or the fundamental right supports intellectual growth. Intellectual growth means educational growth. Educational growth. Okay, so educational growth. For example, right to education was introduced by 86th Amendment Act of 2002. Okay, means child of age 6 to 14 years are compulsory to have the primary education. Are compulsory to have the primary education. Okay, and if a person is educated, then he will intellectually grow. Okay, what is the spiritual growth? The spiritual growth means we have the right to freedom of religion. Right to freedom of religion. Freedom of religion from Article 25 to 28 means everybody has the right to choose their religion, everybody has the right to choose their deity, and everybody has the right to worship. Okay, so this promotes spiritual growth. This is promoted under secularism, the concept of secularism, and the concept of secularism is explicitly mentioned in under Article 25 to 28. Okay, so this is very important that the fundamental right is an indispensable asset for an individual for his physical, intellectual, and the spiritual growth. Okay, so let's move forward. Okay, now why fundamental rights are essential? Now the question comes that why fundamental rights are essential? Rights are essential. Okay, so fundamental rights are very essential for the effective functioning of the democracy. Effective functioning of democracy. Effective functioning of the democracy. Okay. As we know, democracy is a form of government. It is a form of government in which rulers are elected by the people. People of the country. Rulers are elected by the people of the country. Okay, this form of government, and this form of government is only possible if fundamental rights are there. Fundamental rights are there. Okay, if there will be no fundamental right, for example, if you don't have the right to freedom of speech and expression under Article 19, if Article 19 is not available, you cannot do constructive criticism against government. Okay, means constructive criticism will also not be allowed. You don't have the right to express your thoughts. Okay, this is also not allowed. Okay, and you will be forced to cast their vote in the favor of the power. Okay, who will be the more powerful? They will oppress the people. So it is the fundamental right that protects the people from the tyranny of the state. So second one is it protects the people from the tyranny of the state. people from the tyranny of the state. Tyranny of the state. Now, it also prevents the government from becoming authoritative. Okay, let me write it here. It protects the people from becoming authoritative. Okay, and despotic. Okay, what happens in the monarchical form of government? What happens where there is no democracy? Let's understand. So, if there is no democracy, then their rights can be snatched at any time. Their rights can be snatched at any time. If there is no primacy to the constitution, if there is no primacy to the constitution, their rights are just published on the paper. It will become just a simple rights. There will be no practical implementation for that. Okay. So democracy is very important. And for the effective functioning of the democracy, it is the constitution that upholds the democracy. It is the constitution that creates the structure, administrative structure of the country. Okay. We have three-tier government. Okay, we have central level government, we have state level government, and we have panchayat and municipality level. Okay, every government has all the three organs are incorporated. Legislative, executive, and the judiciary. Union level, it's union legislature, union executive, and the union judiciary. At state level, we have state executive, state legislature, and the state judiciary, that is the high court and the subordinate courts. We have the panchayat. At panchayat level, we also have gram sarpanch, gram panchayat, and gram nyaya. Okay, so these are the three-tier structure of the government that has been created by the Constitution of India. Okay, so it is the fundamental right which is very important for the efficient functioning of the democracy. Now let's move on. These fundamental rights are guaranteed and enforced by a fundamental law of the land. Fundamental law of the written law. Okay, so fundamental rights are named so because they are guaranteed and protected by fundamental law of the land. And what is the fundamental law of the land? Fundamental law of the land is basically the Constitution of India. So fundamental right in the Indian Constitution is protected by the Constitution of India. Okay, it is not provided by the ordinary law. It is not provided by the statutory law or any other law. Rather, it is provided and it is guaranteed and it is enforced by the Constitution of India. Okay. Now, let's understand. According to the Granville Austin, let's see what he said. Part 3, it is the fundamental right. Okay. So, what fundamental rights are doing? Fundamental rights can be categorized in two categories. One is negative injunction. And the second one will be positive commandments. So which all fundamental rights are in the negative injunction? So negative injunction means the fundamental rights that prevents the government from doing arbitrariness. Means putting limits on the government. Arbitrariness. Okay. And it is negatively worded fundamental rights. For example, Article 15, Clause 1. It states that the state shall not discriminate. The word is state shall not discriminate against the citizen on the grounds of religion, race, sex, and places of birth. Okay. So this is negatively worded that a state shall not. Okay, so this is negatively worded and they are called as, they are just putting limit on the powers of the government. They are putting limits on the power of the government. That is why it is called as the negative injunction. For example, Article 21. Article 21, that a state shall not deprive a person of his right to life and the personal liberty except the procedure established by the law. It is not only available against the state, but it is also available against the individual. After 2023, after 2023, after the judgment of the Kaushal Kishore versus Union of India case. Okay, so this is also guaranteed. What is positive commandment? So those fundamental rights which conferred rights on the individual, which confers right on the individual, and these are the positively worded fundamental right. For example, Article 19. Article 19 gives you right to freedom of speech and expression. Right to freedom of speech and expression means this article is conferring a right on the individual. Means the fundamental rights can be negatively worded, fundamental rights can be positively worded. If negatively worded fundamental rights are called negative injunction, that are putting limits on the powers of the government, while the positive commandments are conferring certain rights on the individual. Okay, so these are what government cannot do, fundamental right decides. It is the fundamental right that decides that what government can do. Okay, and what government can do is mentioned in part 4. Part 4 talks about the directive principle of the state policy, DPS. Okay, what government can do. What government can do. So part 3 and part 4 of the Indian Constitution forms the conscience of the Indian Constitution or the intellectual part of the Indian Constitution, according to the Granville Austin. So according to the Granville Austin, part 3 and part 4 forms the conscience of the Indian Constitution. Okay, so let me write it. Conscience of the Indian Constitution. It is in the part 3 plus part 4 together constitute the consent of the Indian Constitution said by Granville Austin. Okay, so it is clear. Now, let's talk about the features of the fundamental rights. Features of the fundamental right. So, first feature. Let me explain you something that all the fundamental rights from 12 to 35 are available to the citizen of India. All are available to the citizen of India. Okay, but partial fundamental rights are available to the non-citizen of India. Okay, means some of the rights, some of the fundamental rights are only available to the citizen of India. So the first feature is some of the rights are only available to the citizen of India. Okay. So what are the list of the fundamental rights that are only and only available to the citizen of India? So it's Article 15. Article 15, that is right against discrimination. Right against discrimination. What does it mean? It means it is only available to the citizen against the government. Means a state shall not discriminate. Okay, it is available to the citizen. If a state is discriminating on the non-citizen of India, or a person who is not a citizen of India, then it will not be considered as a discrimination. It is not considered as a violation of the fundamental rights. Violation of the fundamental right of the non-citizen of India. Okay, so Article 15. Similarly, we have Article 16. Article 16 talks about right to public employment. Right to public employment. Okay. So this right is also available only to the citizen of India, not to the foreigners, not to the alien. Okay. So Article 16. So two rights. Let me write it the third one, that it is Article 19. Very important. Article 19. And Article 16 can have an explanation that foreign citizens are not allowed for the public employment in India. Okay. Article 19. Article 19 talks about the right to freedom of speech and expression. Each of the right will be explained in so detail that you will not be able to forget. Right to freedom of speech and right to freedom of speech and expression. Okay, means it is also available to the citizen. Okay, means the foreign citizen cannot claim that I have the right to freedom of speech. I can speak whatever I feel like. No, he has not that right of speech and expression as a fundamental right. He can be detained by the government. Okay, he can be punished by the government, and it will not be considered as a violation of the fundamental right of that person because it is not available to that person. Okay, so right to freedom of speech and expression under Article 19. Okay, the fourth one is called as Article 29. Article 29, that is the cultural right. Everything will be discussed. Cultural rights, and Article 30 will be the educational rights. Educational rights. Educational rights. Okay, so these are the things which are not available. Okay, so Article 15, 16, 19, 29, and 30. So five of them. It is fourth one, and this one is the fifth. So these are the five fundamental rights which are only available to the citizen of India, not to the foreigners. Okay. Now, is this fundamental right is absolute? Now the question comes: is this fundamental right absolute? No. The answer is no. These fundamental rights are not absolute, as a state can impose reasonable restriction. Reasonable restriction can be imposed by the state. But these restrictions are reasonable or not, it is decided by the courts. Okay. So restrictions are reasonable or not, it will be decided by the court. But these fundamental rights are not absolute. Okay, you have the fundamental right of freedom of speech and expression under Article 19, clause 1, subclause A of the Indian Constitution. But it does not mean that you have all the right to say whatever you have to. There are certain limitations, there are certain boundaries which you are not supposed to cross. And if somebody is respecting your freedom of speech and expression, then it becomes your duty to respect his or her freedom also. Okay, now. So second features is very clear that the fundamental right is not absolute. It is subjected to reasonable restriction imposed by the state. And whether the restrictions are reasonable or not, it will be decided by the courts. Okay, now the third one, that the fundamental rights fundamental rights are primarily available against the state. Fundamental rights are primarily available against the state. But some of the fundamental rights are also available against the individual. And these fundamental rights are Article 17. Article 17, that is right, that is abolition of untouchability, right against untouchability, abolition of untouchability. We have right to life and personal liberty. And personal liberty under Article 21 of the Indian Constitution. We have right against exploitation. Right against exploitation. Okay, so these are the rights that are available against the individual also. Okay, but rest of the fundamental rights provide protection primarily against the state action, not against the individual action. But these are the fundamental rights that provides the protection against the state action as well as the individual action. Okay, now let's talk about whether the fundamental rights are sacrosanct. Is fundamental rights are sacrosanct? Is it permanent? Is fundamental rights are permanent? The answer is fundamental right the sacrosanct? No. Fundamental rights are not sacrosanct. Sacrosanct means sacred, which cannot be touched, which cannot be changed. Okay, so these are not considered as sacrosanct. Okay, and these fundamental rights are subjected to the amendments. Fundamental rights are also subjected to the amendment. Means the parliament can repeal the fundamental right. Parliament has the right to amend the fundamental right only by following the procedures mentioned in the Article 368 of the Indian Constitution. Means the parliament has the power to amend each and every part of the constitution except the basic structure of the Indian Constitution. But parliament, while amending the Constitution of India, Parliament has to follow the rules or the procedure mentioned in Article 368 of the Indian Constitution, which talks about the power and procedure of the Parliament to amend the Constitution of India. Power and procedure to amend the Constitution of India. The Constitution of India. So these fundamental rights are not permanent. These fundamental rights are not sacrosanct, and Parliament can repeal the fundamental right using constitutional amendment, which is mentioned in Article 368 of the Indian Constitution. But it cannot be repealed by an ordinary action of the Parliament. Ordinary action of the Parliament cannot repeal the fundamental right. Nine. By simple majority, fundamental rights cannot be amended. Okay. So the procedure must be followed in order to amend the fundamental right. Okay. Now, this one is the fourth feature. Now, let's talk about the fundamental suspension of the fundamental rights. Suspension of the fundamental rights. Fundamental rights. Okay. So fundamental rights can be suspended during the operation of national emergency, except the right guaranteed by Article 21 and Article 20. Okay, these things will be discussed. And this suspension of the fundamental right during the national emergency, is a borrowed provision. It is a borrowed provision and it is borrowed from the Weimar Constitution of Germany. Weimar Constitution of Germany. Part 18 of the Indian Constitution. Part 18 of the Indian Constitution deals with the national emergency from article number 352 to 360. Okay, this talks about the national emergency. Okay. These are the emergency provisions basically. A national emergency is from Article 352 to 356. Okay. And we have also state emergency as well. Okay. So these are the suspension of the fundamental right. And this suspension of the fundamental right is mentioned under Article 358 and 359. Okay. So it is very clear now that these six other rights that are guaranteed by Article 19 of the Indian Constitution can be suspended only when emergency is declared on the ground of war or external aggression. We will discuss the emergency provision, but the fundamental right under Article 19, there are six rights mentioned in Article 19. Okay. So Article 19 consists of six articles. Consists of six rights. And these six rights are suspended during the national emergency if and only if the national emergency is declared on the grounds of war or external aggression. War or external aggression. Okay. War or external aggression means that is the external emergency. Okay. not on the grounds of the armed rebellion. Armed rebellion, on this ground, this Article 19 will not be suspended. Okay. Now, I think it is clear. Okay. So it is very clear. During the war or external aggression, if the national emergency is declared, then Article 19 will be automatically it will be suspended. Okay. Now, let's talk about the fundamental rights of armed forces, paramilitary, intelligence agencies, police forces can be abrogated by Parliament under Article 33. Means Article 33 gives power to the Parliament that they have the right to snatch the fundamental rights from the armed forces, paramilitary, intelligence agencies, police forces, etc. Okay, so now. Now let's understand that what is the difference between the fundamental rights and the ordinary rights. Okay. Okay. So let's understand the difference between fundamental rights and ordinary rights. Fundamental rights and ordinary rights. Okay. So ordinary legal rights are guaranteed, protected, and enforced through an ordinary law of the land. Okay. Means the ordinary rights are protected, enforced, and guaranteed through an ordinary law of the land. Okay. While the fundamental rights are guaranteed, protected, and enforced through the fundamental law of the land, that is the Constitution of India. Fundamental law of the land. Okay. It is through the ordinary law of the land, and ordinary process is followed for conferring certain rights. For example, we have Transportation Act. Okay, 1978. We have Transportation Act. It also confers certain rights to the individual, but these are guaranteed through the ordinary law of the land. These are protected and enforced through ordinary law of the land. While we also have the fundamental rights given under Article 14, right to equality, that is equality before law and the equal protection of law. This is the right which is protected by the fundamental law of the land. So the first difference is very clear that the ordinary law is protected, enforced, or guaranteed by the ordinary law of the land, while the fundamental rights are guaranteed, protected, and enforced by the fundamental law of the land. Okay, now the second one, ordinary legal rights may be changed by the legislature through the ordinary process of lawmaking, whereas the fundamental rights can only be changed by amending the Constitution of India. And I already discussed, to amend the Constitution of India, Parliament has to follow the procedure mentioned in Article 368 of the Indian Constitution. I'll talk about the process of the amendability of the Indian Constitution in one of the lectures. Okay, in one of the upcoming lectures. Okay, now the third difference, that in case of violation of the fundamental right, if fundamental right of an individual is violated, then he has the right to approach the Supreme Court of India without having any letter of appeal from the High Court under Article 32, right to constitutional remedy. Okay, and he can also approach the High Court of India under Article 226 of the Indian Constitution. Okay, now the question comes that if ordinary legal rights are violated, what he can do? He cannot directly approach the Supreme Court of India, but he can approach the Supreme Court of India by having a letter of appeal from the High Court. Okay, so this is clear. Very much the features, the difference, and everything is clear. Now, in the next lecture, I'll start with Article 12 and we'll continue further. Okay, so let's end here only.